Hello, everybody. I'm Ugo Pagallo, professor of jurisprudence at the University of Turin in Italy. And, well, it's a pleasure to be with you at the ICAIH 2020 conference at the University of Chunang in Seoul, Korea. First of all, let me thank the organizers of this conference on AI and future society. And of course, I would have liked to be personally and physically with you in Seoul, but for obvious reasons, for the time being, this is not possible. And let's hope that's going to be possible once again anytime soon. The topic chosen for today's presentation is, as you can see, the future of AI and the society of the future. And the particular angle, perspective, stance I've chosen in order to address this topic has to do with the law, ethics, and governance of AI. Since I've been given 15 minutes, let's try to pack all these hot topics according to these points. Let's start shortly with the definition of artificial intelligence, its role in today's societies, so as to start thinking about the future of our current information societies. Against this backdrop, then we'll mention the ethical and legal debate concerning the normative challenges of AI, so as to dwell finally on the governance of artificial intelligence, and then we'll draw some conclusions. So to start with, here you have a sort of classical table concerning the different ways in which scholars defining AI over the past 60 years. My source, as you can see, is a classic textbook by Stuart Russell and Peter Norwig, so that we can think about our field in terms of machines and systems which are able to think humanly or rationally, to act rationally or humanly. And on top of that, of course, we can further distinguish between strong artificial intelligence approaches or more realistic weak ones and the like. But here, luckily enough, our problem is not to find out a workable, common, strict definition of AI, but to pay attention to the normative challenges brought forth by this disruptive technology. And moreover, we have to think about how AI is affecting basic tenets of the law, ethics, politics, in light of one fundamental fact, namely the fact that we are already living in what can be dubbed as an information society. What does it mean? Well, it means that for the first time ever in our history, or history of human societies, the latter doesn't only use information communication technologies, but they depend on ICTs, that is, information communication technologies. And, well, this is a game changer in order to understand what's next. We have to understand, in other words, the role AI will have in this context, in the sense that if we are already living in information societies, well, AI cannot but strengthen this trend. So much so that maybe you know that a couple of years ago, the president of Russia, Vladimir Putin, affirmed that was going to be the leader in this field of technological innovation, will be the leader of the world. And, all lawmakers, in addition to the Russian president, are pretty aware of the crucial role AI will have in our societies, and that's the reason why there has been really hot institutional debate over the past years, both in Washington, D.C. and in Brussels concerning the European Union. But of course, the same applies to such countries as South Korea, Japan, Australia, and the like. Well, here point that had to be stressed, namely the role political decisions will have in order to shape our information societies in the future. Typical example of political decision has to do with an alternative between zero-sum games and human AI cooperation, namely the fact that we may think about AI and research in this field as a human substitute, or you may think about current research and development in AI as a way to strengthen the collaboration between social technological systems and with humans. And those political decisions, what is more, have to be considered of in light of the unique set of challenges triggered by AI in all fields of our current societies. Of course, taking into account benefits and opportunities of this technology. Well, in light of this set of issues concerning the role of AI, political decisions that shall be taken considering the unique set of challenges triggered by AI with benefits and opportunities, it's not a matter of surprise that a hot ethical debate has been evolving over the past years. Let me mention here the document on trustworthiness of AI, published by the group of experts on the ethics of AI, set up by the European Commission a couple of years ago. And you can find this document online partially, and especially at the very beginning. This report was inspired by a paper that a group of colleagues and friends has published in 2018, the AI for People paper on an ethical framework for AI, in which not only the challenges which are unique to AI are highlighted, but there are some recommendations about how to tackle the uniqueness of these ethical challenges, considering not only problematic uses of this technology, but also risks of underuse of this technology. However, we have added another narrative dimension to our analysis. That is, it has been really important that scholars and institutions have been focusing on the ethical principles concerning the use and further development of this technological field. But in some cases, the pressure has been that by focusing on the ethical challenges of AI, we could simply forget about the legal challenges brought forth by this technology. So that in a way, we may wonder about how to connect this part of today's debate concerning, again, the ethical principles of AI and the legal issues of our technological domain. Here you can see the cover of a book which I recently, a couple of weeks ago, published with Woodward Barfield, in which we offer, or at least we hope to offer you an overall picture of what's going on with AI in the legal domain. And as you'll see and find out in this book, we examine how AI is affecting tenets of current human rights frameworks, constitutional frameworks, intellectual property frameworks, data protection frameworks, and the like. Here, I should mention the fact that I've been working on a specific facet of this legal challenge of AI, namely focusing on liability, churches' liability, and extra contractual responsibility for the use of AI as a member of another group of experts, the group of experts on liability and new technologies formations, set up by the European Commission a couple of years ago. And, going back to my previous question, we have a lot of ethical issues concerning AI. We have a lot of legal issues concerning AI, how we should understand this connection between ethical and legal issues. Well, of course, there is a hot debate on this very point. My personal opinion is that whereas in the case of ethical challenges of AI, the focus of scholars and institutions is about how to strengthen the current normative framework, starting with, for example, here in Europe, the 1950 European Convention on Human Rights and the 2000 European Union's Charter of Fundamental Rights. Well, in the case of the law and the legal debate on the normative challenges of AI, focus has been mostly on what we call here in the European Union's legal system secondary rather than primary legislation, if you want, orderly rather than constitutional amendments to the law. However, these very ethical and legal dimensions of today's debate on AI, should stress some further relevant points concerning this technology in terms of governance. That is, how should we govern this dynamic field of technological research and innovation? Well, In this case, attention should be drawn to the fact that the governance of AI is already largely context dependent. That is, of course, we have general principles concerning the ethical and legal domain. I previously mentioned the 1950 European Convention on Human Rights. Still, most legal systems already regulate AI in a context-dependent way. That means that, for example, if we are thinking about AI application concerning drones, that is unmanned aerial systems, well, we'll find out several specific laws concerning this specific case. The same applies to the field of unmanned vehicles or self-driving cars, or to the use of AI in the health sector, in the financial sector, and the like. So that when we are thinking about and even discussing what are or should be the new ethical, moral, and legal principles governing the use of AI, well, we shouldn't forget the context dependency of most regulations affecting the design and use of AI in most legal systems. However, thinking about the governance of AI, we should stress a second point, which is very important, namely the insufficiency of top-down approaches in the field of AI. That is, on the one hand, even traditional top-down approaches, as in, for example, the already mentioned regulations for the use of drones in the field of civil aviation, well, in many cases, this traditional top-down approach is complemented by further measures of soft law and cooperation. For example, in the field of civil aviation in the European Union, we should mention the role of EASA, the European Agency for Aerial Security, in addition to the executive powers of the European Commission. In other cases, because of this insufficiency of top-down approaches, well, lawmakers have adopted new models of regulation. Here, for example, the new models can be illustrated with the GDPR, which is the European Union's General Data Protection Regulation, in which, of course, you will find out several provisions which are inspired by a traditional top-down approach. However, the general legal framework set up by the GDPR hinges on the so-called principle of accountability in accordance with Article 5 of that regulation. And, well, the principle of accountability functions as a sort of interface between a traditional top-down approach, namely the set of principles enshrined in the first section of Article 5 of the GDPR, and on the other hand, self-regulatory measures, both at the technological and organizational level, in order to abide by the provisions of the European legislators. We should add to these new models of regulation, new methods of regulation through experimentation. This is what's happening all around the world in the field of self-driving cars. This is an approach that, for instance, has been very popular in Japan, and that the Japanese government has been establishing a series of open labs, toku in Japanese, in order to understand how the human-robot, the human-AI interaction may work and develop in certain crucial fields as concerning tax regulations, data protection, security, and the like. As I said previously, we have to pay attention to the role of soft law. This is very important. I already mentioned the case of IASA powers in the EU law, and this role of soft law is going to be really important in order to define the new generation of standards, both technical and legal in this domain. And this is actually what's occurring in the field of civil aviation law. And it's very telling the fact that when you will not find a, so to speak, strong soft law, for example, in the field of unmanned vehicles, autonomous vehicles, self-driving cars, well, the lack of a robust soft law most of the time suggests the difficulties of a certain field, self-driving cars, in order to define their own new set of standards. And finally, we have to mention the role of coordination mechanism here. That is, how to define, once again, the interface between top-down and bottom-up regulatory solutions. Well, in light of this overall picture, so it's important to stress both the context dependency of several legal regulations concerning the field of AI, and the importance that coordination mechanisms will play because of the shortcomings of traditional top-down, not to talk about bottom-up approaches. And a good instance here is given by this current project, AI for Health of the World Health Organization, a project in which, again, I'm a proud member of two groups, subgroups working on privacy and coordination mechanism in the field of health and the role that AI may play and in some cases shall play in this domain. So time for the conclusions. As you've seen, AI will play a crucial role and is already playing a crucial role in today's information societies. This technology is disruptive. Several challenges are unique to this technology and is affecting such tenets of the law, and is suggesting to rethink our current moral principles, in the sense that, as we suggested with the aforementioned AI for People paper, well, we should complement current principles of the moral debate, paying attention to a new moral principles, that is explainability. These new ethical and legal challenges were examined in the light of a wider framework that is how we should govern. And so what kind of governance, of model of governance we should adopt in this field. I stressed that traditional top-down regulatory approaches are not sufficient. We should pay attention to methods of coordination, to the role of soft law, and to new methods of legal experimentation, for a fundamental reason, that is thinking about what the future of our current societies could be vis-a-vis further development of AI. Of course, political decisions shall be taken because, in a way, the future is already here. Thank you very much, and hope to see you soon personally in Seoul. All the best.